Before we begin, a quick and important disclaimer. The historical data, legal analysis, legislative timelines, and demographic statistics discussed in this comprehensive presentation are strictly for educational and entertainment purposes only. We are diving deeply into the complex evolution of family law, socioeconomic trends, and statistical shifts regarding divorce in the United States over the past century. However, this historical analysis does not constitute professional legal advice, financial counsel, or psychological guidance. Family law is inherently complex, heavily dependent on specific state jurisdictions, and constantly evolving based on new precedents, local statutes, and legislative reform. The historical trends and demographic case studies we will explore represent population-level outcomes and aggregated statistical data spanning several decades. They do not predict, dictate, or outline specific potential outcomes for individual viewers. If you are currently navigating a divorce, a legal separation, child custody proceedings, or any related legal family matter, it is absolutely critical that you conduct your own independent due diligence and retain qualified, licensed legal counsel who can analyze the unique facts and specific nuances of your personal situation. Do not use the historical demographic data or legislative timelines presented in this masterclass as a substitute for a licensed attorney, a certified financial planner, or an accredited tax professional. Every legal scenario is highly unique, and historical trends are meant for macro-level understanding, not micro-level legal strategy. Imagine going to sleep on December 31, 1969, secure in the absolute bedrock of American marital tradition, only to wake up the next morning in a legal landscape that had been entirely and permanently rewritten. For generations of American men, the dissolution of a marriage was a profound statistical anomaly. It was a grueling, highly public, and socially stigmatized process that required definitive legal proof of fault, such as documented adultery, physical abandonment, or extreme cruelty. The overarching legal framework of the early 20th century was intentionally designed to make divorce exceptionally difficult and expensive to obtain. Because of these immense barriers, the demographics of divorced men were overwhelmingly confined to two distinct extremes: the extraordinarily wealthy who could afford complex, protracted legal battles and private investigators, or those on the absolute margins of society. For the vast majority of the American middle class, divorce simply was not a viable economic or social option. But then, a quiet, seemingly progressive piece of legislation was signed into law in California by then-Governor Ronald Reagan. This was the Family Law Act of 1969, marking the birth of no-fault divorce in the United States. It triggered a demographic shockwave that fundamentally altered the financial, social, and psychological trajectory of the American male, effectively changing the institution of marriage from a permanent, state-enforced bond into an at-will contract. Overnight, the legal necessity to prove marital wrongdoing vanished. The divorce rate in the United States skyrocketed, completely transforming the demographic landscape as the rate doubled between 1966 and 1979. However, here is the shocking historical reality that traditional sociology classes completely ignore: the devastating disproportionate impact this unprecedented legal shift had on specific demographics of men. While the overall national divorce rate climbed to hover around 40 to 50%, the resulting financial ruin and the loss of custodial rights did not impact all men equally. There was a hidden, silent demographic marker, a highly specific intersection of socioeconomic status, geographical location, educational background, and generational wealth that determined exactly which men were essentially wiped out by the new family court system, and which men managed to navigate the transition with their assets and their families relatively intact. The modern mainstream narrative often suggests that the legal system simply evolved to become more equitable, but the raw, unvarnished historical data tells a much darker, incredibly complex story about massive wealth transfer, legislative blind spots, and the rapid expansion of a family court system that frequently overwhelmed the American working and middle-class man. We are going to expose that hidden demographic marker. We will examine the exact historical moments where the rules of the game were fundamentally changed without broad public comprehension, leaving millions of men fighting a legal and financial battle they did not even realize they were in. We will trace this back even further, exploring how the shift from an agrarian society to the Industrial Revolution completely inverted how the legal system viewed fathers. In the agrarian era, men were universally awarded custody because children were viewed as vital labor for the family farm. But as men moved into factories during the Industrial Age, the courts adopted the tender years doctrine, a legal presumption that fundamentally stripped men of their default custodial rights, branding them solely as financial providers rather than primary caregivers. You will discover how the legal precedents set during these crucial eras established a concrete blueprint for modern alimony, asset division, and child support that continues to dictate the lives, incomes, and futures of millions of American men today. This is not just a distant story about the past. It is the definitive origin story of the modern American family structure and the very specific legal vulnerabilities inherent within it. You are here today because the modern discourse surrounding marriage, divorce, and the rights of men is heavily saturated with raw emotion, conflicting opinions, and dangerous misinformation. You are looking for absolute clarity, and that clarity can only be found by stripping away the modern rhetoric and examining the cold, hard, heavily documented historical data. The objective of this deep dive masterclass is to provide you with an unfiltered, meticulously researched timeline of the demographics of divorce for men in United States history. By the end of this presentation, you will no longer be relying on generalized anecdotes, internet rumors, or societal fear-mongering. Instead, you will be armed with a deep, structural understanding of how American family law evolved, how demographic trends have historically shifted, and precisely what those historical shifts mean for the current legal and financial landscape. We are going to analyze extensive historical trends and highly detailed case studies pulled directly from the United States Census Bureau, historical legal archives, and peer-reviewed sociological research spanning over a century. This rigorous analysis is specifically designed to solve a critical, life-altering problem for the modern American man: the profound lack of historical context required to make informed, rational, and highly strategic decisions about marriage, family planning, and lifelong asset protection. By understanding exactly how the courts and the state legislatures have historically treated different socio-economic demographics of men over the past 150 years, you gain the analytical tools necessary to understand your own statistical realities today. You will learn to recognize the recurring economic and legislative patterns that always precede major shifts in family law. This knowledge allows you to view the institution of marriage not merely as a romantic cultural ideal, but as the single most significant legal and financial contract you will ever enter into in your lifetime. We will relentlessly decode the history of the past so that you can clearly comprehend the realities of the present, ultimately transforming historical vulnerability into educated, unshakable awareness. To understand the modern realities of 2026, we have to travel back to the foundational bedrock of American family law. Long before the massive courthouses and complex child support algorithms we see today even existed. We must start with the agrarian paradigm of the 18th and early 19th centuries, a time when the legal framework governing men, marriage, and divorce was dictated by the English common law concept of coverture. Under coverture, a husband and wife were considered a single legal entity, and that entity was entirely controlled by the husband. This historical reality is often brought up in modern discourse to illustrate historical male privilege, but an objective analysis of the demographic data reveals a much more complicated and highly burdensome picture for the everyday man. While the man held the legal rights to property and income, he also carried the absolute, inescapable legal liability for his family. If his wife accumulated debt, he was solely responsible. If she committed certain civil offenses, he faced the legal penalties. Marriage was not just a social union. It was an ironclad economic partnership centered entirely around basic survival. Divorce during this agrarian era was statistically negligible. It was not handled by a local family court judge but required a literal act of the state legislature. Imagine a man named Josiah in the year 1820 living in rural Pennsylvania. If Josiah wanted to dissolve his marriage, he could not simply cite irreconcilable differences or complain about a lack of emotional fulfillment. He had to petition the state government, present overwhelming and undeniable evidence of severe faults such as documented adultery or total abandonment, and have his personal tragedy debated by politicians on the legislative floor. It was an incredibly expensive, highly public, and socially devastating process that was entirely out of reach for the average working man. Therefore, the demographic profile of the divorced American male in this era was almost exclusively limited to wealthy merchants or powerful politicians, who possessed the immense capital and social leverage required to push a private bill through a state legislature. However, when these rare divorces did occur, the outcome for men regarding child custody was universally absolute. Under the agrarian legal model, fathers were the default custodians of their children. This was not driven by modern concepts of emotional bonding or psychological well-being, but by cold, hard agricultural economics. Children were essential labor units required to maintain the family farm and ensure the economic survival of the household. The courts and legislatures viewed children as the property and the primary responsibility of the father, who held the absolute duty to train them in a trade and provide for their material upkeep. The mother, under the constraints of coverture, had virtually no independent legal standing or economic means to support children outside of the marriage. Therefore, the early demographic reality for a divorced man was one of total custodial responsibility coupled with absolute financial burden. But society was about to undergo a radical transformation that would permanently alter the legal standing of the American male. The mid-19th century brought the explosion of the Industrial Revolution, fundamentally rewiring the economic structure of the United States. Men like our hypothetical Josiah were no longer working the land alongside their families. Instead, millions of American men were physically separated from the homestead, migrating into dense urban centers to work grueling hours in factories, foundries, and industrial plants. This massive demographic migration created a profound spatial separation between the spheres of work and domestic life. The home transitioned from being a center of shared economic production into a sanctuary from the harsh realities of the industrial world, and the management of this domestic sanctuary was assigned exclusively to women. This societal shift triggered one of the most critical and devastating legal pivots in the history of men and divorce: the widespread judicial adoption of the tender years doctrine. As men vanished into the industrial machine for 12 hours a day, the courts began to recognize that fathers were no longer physically present to provide daily care. The legal system, struggling to adapt to this new industrial reality, established a powerful legal presumption that children, particularly those in their tender years, naturally and inherently belonged with their mothers. This was a catastrophic demographic turning point for men. Practically overnight in the historical timeline, the American man was legally demoted from the default head of the household and primary custodian to a secondary figure whose sole legal value in a divorce was his capacity to generate industrial wages. The courts effectively ruled that a man's primary utility was financial extraction. Think about a typical American man, let us call him Michael, navigating the family court system in the current year of 2026. When Michael faces a custody battle and feels the overwhelming, systemic bias that seemingly views him more as a paycheck than a parent, he is not experiencing a modern glitch in the legal matrix. He is experiencing the direct, unbroken legacy of the tender years doctrine born from the smoke of the Industrial Revolution over a century and a half ago. The legal framework built in the 1800s was explicitly designed to separate men from their children and tether them solely to their wallets, and that core architectural code still runs deep within the algorithms of modern family law. The demographics of divorced men shifted from custodial fathers to isolated financial providers, establishing a massive population of men who were legally mandated to fund households they were no longer permitted to live in or lead. This transition created an incredibly dangerous legal vulnerability for the American male. As the 19th century bled into the early 20th century, the industrial wealth of the nation exploded, and the middle class began to rise. With this rise in general prosperity, the state legislatures began transferring the power of divorce down to local judges, making the process slightly more accessible, but still heavily reliant on proving absolute fault. The courts, now armed with the tender years doctrine and a rapidly growing population of wage-earning men, began to construct the modern machinery of alimony and asset division. Judges were granted sweeping, unchecked discretionary power to financially penalize men based on perceived marital misconduct. A man could be stripped of his life savings, his property, and his children on the word of a single judge, leading to a massive, unprecedented transfer of wealth away from the male demographic. But what happens when the legal standard of fault becomes weaponized by a booming new industry of aggressive trial lawyers? What happens when entire states decide to turn the destruction of marriage into a highly profitable tourism industry, setting a terrifying trap that millions of men would blindly walk right into? To answer that, we must look at the Roaring Twenties and the Great Depression era, a time when the American legal system experienced a phenomenon that completely upended the demographics of divorce. Up until this point, the rigid requirement to prove severe fault, like physical adultery or absolute abandonment, kept the divorce rate relatively low and geographically localized. But as the American middle class accumulated more property, homes, and bank accounts, certain states recognized a massive untapped economic opportunity. They realized that if they lowered the barrier to entry for divorce, they could attract a massive influx of out-of-state wealth. This birthed the era of migratory divorce, more commonly known as the divorce tourism industry. Nevada led this charge with aggressive, calculated legislative precision. State lawmakers realized that unhappy spouses, predominantly from strict eastern states like New York or Pennsylvania, were desperate for a legal exit. So, Nevada systematically reduced its residency requirement. By the early 1930s, a person only needed to reside in Nevada for 6 weeks to be considered a legal resident eligible to file for divorce in its courts. This was not an accident. It was a state-sponsored economic stimulus package built entirely on the dissolution of out-of-state marriages. The local economy of Reno exploded with divorce ranches, specialized hotels, and an army of aggressively marketed attorneys whose sole purpose was to process these out-of-state filings as rapidly as possible. But let us look at the devastating impact this had on the demographics of American men. This system weaponized the United States Constitution against the working middle-class husband. Under the full faith and credit clause of the Constitution, a legal judgment made in one state must generally be respected and enforced by all other states. The divorce tourism industry exploited this clause ruthlessly through a legal mechanism known as an ex parte divorce. An ex parte proceeding allows a judge to make a ruling based on the presence and testimony of only one party. Imagine a scenario involving an industrial manager named William, living in Chicago in 1938. William goes to work every day, pays his mortgage, and believes his marital contract is governed by the strict, fault-based laws of Illinois. His wife tells him she is taking a multi-week vacation out west to visit family or improve her health. 6 weeks later, William is served with legal papers. His wife has established temporary residency in Nevada, hired a local Reno attorney, and filed for divorce. Because Nevada courts were highly motivated to process these cases to keep the tourism revenue flowing, they dramatically expanded the definition of fault. They allowed incredibly vague accusations of mental cruelty or extreme emotional distress to satisfy the legal requirements for dissolution. William is now trapped in a jurisdictional nightmare. He is sitting in Chicago, and he is suddenly facing a trial 3,000 miles away in a state where he does not live, where the local judges are economically incentivized to rule in favor of the plaintiff bringing out-of-state money into their town, and where the legal standard for proving fault has been intentionally watered down to almost nothing. To fight these accusations and protect his assets, William would have to leave his job, travel across the country, hire a second attorney in Nevada, and fight a battle on hostile legal territory. For the vast majority of middle-class men in this demographic, this was financially impossible. As a result, millions of men like William suffered default judgments. Because they could not physically or financially appear in the Nevada court to defend themselves, the judge would rule entirely based on the unverified testimony of the spouse. The court would grant the divorce, assign all the fabricated fault to the absent husband, and issue crushing alimony orders and asset division mandates. Thanks to the full faith and credit clause, William is legally bound by his home state of Illinois to enforce this out-of-state destruction. His wages in Chicago could be garnished, and his property could be liquidated to satisfy a debt created in a courtroom he had never even seen. This historical era marked a profound shift in the demographics of financial ruin for men. It proved that geographical distance and jurisdictional loopholes could be used to bypass the traditional protections of a local family court. It transformed the legal profession as well. Attorneys saw the immense profitability of aggressively pursuing a spouse across state lines to target their assets. The localized legal proceedings of the 19th century were replaced by a highly adversarial, profit-driven legal machine that viewed the American husband as a heavily resourced target. We see echoes of this exact same jurisdictional warfare today. Fast forward to the current year of 2026, and consider a man named James living in a state with relatively conservative alimony laws, like Texas. If his spouse quietly relocates to a high alimony jurisdiction like California or Massachusetts, establishes residency, and files for divorce there, James suddenly finds himself fighting a modern version of the ex parte battle. He is subject to the asset division rules and long-term support calculations of a state he does not reside in. The historical trend of exploiting geographical boundaries to maximize financial extraction from men did not end in the 1940s. It simply became digitized and integrated into modern interstate family law. The divorce tourism era exposed a fatal flaw in the fault-based system. It proved that requiring a reason for divorce only resulted in widespread perjury, fabricated accusations of cruelty, and intense jurisdictional manipulation. The legal system was drowning in an absolute mockery of justice, where the wealthy could simply buy a 6-week vacation to dissolve a marriage, leaving the abandoned spouse financially devastated by default. State governments across the country watched the massive wealth transfer happening in places like Reno, and they realized they were losing out on a highly lucrative legal market. The pressure was building for a massive nationwide overhaul. The states realized that if they wanted to capture that legal revenue and stop the exodus of angry spouses crossing state lines, they had to completely remove the requirement of fault altogether. They had to make the destruction of the family unit incredibly easy, localized, and highly efficient. The stage was set for the single most destructive piece of legislation regarding male demographics in American history. What happens when the state decides to completely eliminate the concept of marital fault, turning marriage into the only binding legal contract in the world that can be unilaterally broken by one party without any penalty whatsoever? The answer to that devastating question begins in the state of California in the year 1969. In what was initially framed as a progressive move to reduce courtroom perjury and alleviate the backlog of highly contested family law dockets, Governor Ronald Reagan signed the Family Law Act. This legislation introduced the concept of no-fault divorce to the United States, allowing a marriage to be legally dissolved solely on the grounds of irreconcilable differences. The initiating spouse no longer had to provide any evidence of abuse, adultery, or abandonment. They simply had to declare to the court that they no longer wished to be married. This single legislative signature triggered the most profound and rapid shift in the demographics of divorced men in modern history, unleashing an unprecedented legal and financial shockwave that completely rewrote the rules of American family structure. To understand the sheer magnitude of this shift, we must analyze how this legislation completely mutated the legal definition of the marital contract. In the current year of 2026, if you enter into a standard business contract, a real estate lease, or a corporate partnership, fundamental contract law dictates that if one party unilaterally breaches the agreement without cause, that breaching party is legally liable for damages. They are penalized for breaking the contract. No-fault divorce completely inverted this foundational pillar of Western jurisprudence. Marriage became the only legally binding, state-recognized contract in the world where a party could unilaterally decide to break the agreement for any reason, or no reason at all, and face absolutely zero legal or financial penalty for the breach itself. In fact, under the community property and equitable distribution laws that accompanied this shift, the party breaking the contract was structurally guaranteed to walk away with a massive share of the accumulated assets, and potentially a legally enforced stream of future income from the spouse who was broken against. Imagine a man named Thomas living in suburban Ohio in the year 1974. Thomas is a mid-level mechanical engineer working for a major automotive manufacturer. He has spent the last 15 years working 50 hours a week to pay off a 4-bedroom home, build a modest savings account, and secure a company pension. Under the old fault-based system, his wife would have faced an incredibly high legal hurdle to dissolve the marriage and extract his wealth unless Thomas had committed a severe, provable offense. But as states rapidly followed California's lead, Ohio adopted no-fault statutes. Suddenly, Thomas is handed divorce papers. He has committed no civil wrong. He has not broken any law. He has faithfully provided for his family. Yet, simply because his spouse declared irreconcilable differences, the local family court forcefully intervenes in his life with the full weight of state authority. The court orders the forced liquidation of Thomas's primary residence to satisfy a 50-50 split of the equity. The judge signs a qualified domestic relations order, permanently severing half of the pension Thomas had spent his entire adult life building. Because Thomas is the primary breadwinner, the court orders him to pay standard alimony, drastically reducing his monthly take-home pay. Thomas is abruptly forced out of his home and moves into a small, rented apartment, his standard of living completely decimated, while he continues to legally fund his former household. This is not just a hypothetical tragedy. This became the exact demographic reality for millions of middle-class American men in the 1970s and 80s. When we analyze the historical data regarding who was destroyed by this transition, a clear demographic bullseye emerges. The exceptionally wealthy elite possessed complex trust funds, offshore accounts, and corporate shelters that insulated them from the blunt force trauma of standard asset division. The severely impoverished had virtually no assets for the state to divide. The entire financial weight of the no-fault divorce revolution collapsed directly onto the shoulders of the working and middle-class male. For this specific demographic, their entire net worth was almost always tied up in a single piece of real estate and a primary retirement account. When the family court system forced the liquidation and division of that single home, it eradicated the foundational generational wealth of the American middle-class man overnight. Fast forward to the year 2026, and consider a man named David entering a family courthouse in Florida. David mistakenly believes that because society has modernized, the family court system will logically consider the context of his divorce. He assumes the judge will care that his spouse was entirely financially reckless, secretly accumulated massive credit card debt, and engaged in documented infidelity. David is stepping into a legal slaughterhouse perfectly designed to ignore his reality. He quickly discovers that under the modern application of no-fault law, his spouse's behavior is completely inadmissible and legally irrelevant to the division of assets. The modern court operates as a highly efficient, bureaucratic processing plant. The judge does not look at morality, loyalty, or breach of trust. The judge only looks at spreadsheets, asset columns, and state-mandated formulas. To process this massive state-sponsored dissolution of the nuclear family, state governments had to radically expand their judicial infrastructure. The introduction of no-fault divorce birthed a sprawling, multi-billion-dollar divorce industry. An entire ecosystem of mediators, forensic accountants, child custody evaluators, and specialized family law attorneys flooded the market, explicitly feeding off the carcass of the middle-class estate. This industry recognized a terrifying mathematical truth. The longer and more hostile the divorce process, the more capital they could extract in billable hours. Under the no-fault system, the incentive for an amicable settlement completely vanishes if the initiating party knows the state already guarantees them half of the marital estate regardless of their own conduct. The psychological toll on the male demographic during this historical transition was catastrophic. Historical trends from the late 20th century show a direct correlation between the implementation of no-fault divorce and a severe spike in depression, substance abuse, and suicide rates specifically among divorced men. The state had effectively institutionalized the legal alienation of the father, stripping men of their homes, their wealth, and their daily presence in their children's lives, reducing them to the status of a visiting financial utility. The legal framework was efficiently separating the man from his capital, but the courts quickly realized that merely dividing a bank account or forcing the sale of a house was not enough to sustain this new societal structure. They needed a perpetual legally enforced revenue stream to ensure the newly single-mother households did not become a burden on the state welfare system. They needed a mechanism to keep the divorced man permanently tethered to his former life, forcing him to fund a household he was legally evicted from, under the constant, looming threat of incarceration. How did the federal government step in to weaponize the collection of this revenue, creating an inescapable lifelong financial dragnet that still traps millions of men today? To answer that, we must examine one of the most consequential, yet least understood, pieces of federal legislation in American history, Title 4D of the Social Security Act, passed in 1975. As the no-fault divorce revolution of the 1970s swept across the nation, it created an explosive unintended consequence for state and federal governments. The massive proliferation of single-mother households led to a catastrophic drain on the federal welfare system, specifically the Aid to Families with Dependent Children program. The government realized that the state-sponsored dissolution of the nuclear family was bankrupting the public treasury. Their solution was not to repair the legal structure of marriage, but to completely federalize the collection of child support, effectively transforming the American family court system into a highly militarized, state-run collection agency. Title 4D fundamentally altered the financial relationship between the federal government, state family courts, and divorced men. To force states to aggressively collect child support, the federal government created a massive financial incentive program. Washington began matching state funding for establishing child support enforcement agencies, and most crucially, started paying states a direct commission based on the total volume of child support they collected. The demographic implications of this were terrifying. Overnight, state governments were given a profound, structural financial incentive to maximize child support orders. The higher the monthly obligation placed on the father, the more federal matching funds the state treasury received. The American man was no longer just a financial provider for his family. He was legally transformed into a highly profitable revenue stream for the state government. Family courts were no longer impartial arenas of justice. They were federally subsidized economic engines that relied on high child support yields to balance state budgets. To maximize this revenue extraction, the legal system developed a highly aggressive mechanism known as imputed income. Under standard legal and economic principles, a person is taxed or assessed based on the actual verifiable money they earn. The family court system completely bypassed this reality. If a judge felt a man was voluntarily underemployed, or simply capable of earning more, the court could legally impute an income to him. This means the judge could legally mandate child support payments based on a hypothetical, imaginary salary that the man was not actually making. Imagine a man named Christopher navigating this system in our current year of 2026. Christopher is a specialized logistics manager living in Michigan. During a massive corporate downsizing, he loses his position where he was earning $80,000 a year. Despite diligently applying for comparable roles, the current economic climate forces him to take a transitional job earning $40,000 a year just to survive. When Christopher goes to family court to request a downward modification of his child support to reflect his actual, devastating economic reality, he is met with the cold, bureaucratic machinery of imputed income. The judge looks at Christopher's work history, declares that he possesses the earning capacity of an $80,000 a year employee, and refuses to lower the child support obligation. Christopher is now legally ordered to pay a percentage of an income that literally does not exist. When Christopher inevitably falls behind on these mathematically impossible payments, he crashes headfirst into the Bradley Amendment. Passed by Congress in 1986, the Bradley Amendment is an unprecedented legislative anomaly that violates almost every foundational concept of debt relief in the United States. Under this federal law, child support arrears become a specialized, indestructible class of debt. A judge is strictly prohibited by federal law from retroactively reducing or forgiving child support debt, regardless of the circumstances. If Christopher had fallen into a coma, been falsely imprisoned, or suffered a catastrophic workplace injury, the debt continues to accrue, often with massive, compounding state interest rates attached. Unlike consumer debt, medical debt, or even massive corporate bankruptcy, child support arrears can almost never be discharged in a Chapter 7 bankruptcy proceeding. This intersection of imputed income, massive state financial incentives, and the indestructible nature of the Bradley Amendment recreated the modern equivalent of a debtor's prison, explicitly targeted at the demographic of working-class divorced men. When a man falls into arrears, the state deploys a terrifying arsenal of enforcement mechanisms. The state can unilaterally intercept his tax returns, empty his bank accounts, garnish up to 65% of his disposable income, revoke his professional licenses, suspend his hunting and fishing permits, deny him a United States passport, and suspend his driver's license. Consider the sheer, inescapable paradox of that final penalty. The state demands that a man pay a massive financial obligation, and when he cannot, the state legally removes his ability to drive to the very job required to generate the revenue the state is demanding. When all these administrative punishments fail to extract the mandated capital, the final enforcement tool is civil contempt of court, leading to physical incarceration. Thousands of men are quietly jailed every single year in the United States, not for committing a violent crime, but simply because they failed to satisfy a civil debt obligation created by a family court algorithm. This demographic reality creates a permanent, subterranean class of disenfranchised American men, stripped of their assets, crushed by undeletable debt, and living under the constant, looming threat of a jail cell simply for being economically incapable of meeting an artificially inflated state mandate. The federal government successfully built a flawless, inescapable financial dragnet that successfully shifted the burden of the welfare state onto the backs of individual men. But the financial destruction of the father is only one half of the modern divorce industry equation. What happens when the state effectively reduces a man to nothing more than a highly regulated, easily penalized automated teller machine? What happens to the psychological stability of the children when the legal system structurally rewards the custodial parent for completely erasing the father from the child's life? We are about to uncover the dark, deeply controversial psychological weapon that is utilized in family courts across the country every single day. A phenomenon that destroys the mental health of millions of children, while judges simply look the other way. To understand the psychological erasure of the father in the modern era, we must explore a phenomenon that became statistically significant in the 1980s and has reached epidemic proportions by the year 2026: the tactical use of parental alienation. As the financial machinery of Title 4D made children a source of state-subsidized revenue, the legal battle for primary custody shifted from a dispute over welfare to a battle for absolute control. Parental alienation is a systematic process where one parent uses psychological manipulation to turn a child against the other parent, effectively programmed to view the father as an enemy, a villain, or a stranger. In the demographics of divorce, men are disproportionately the targets of this specific psychological strategy, as the historical inertia of the tender years doctrine still grants mothers primary residential custody in the vast majority of contested cases. This is not merely a byproduct of a high-conflict divorce, it is often a calculated legal maneuver. In the adversarial family court system, if a parent can demonstrate that a child is fearful of or resistant to seeing the other parent, that evidence can be used to restrict visitation, justify supervised contact, or terminate parental rights altogether. For many men, the process begins with subtle gatekeeping. It starts with a missed weekend due to a fabricated illness or a last-minute birthday party that the father was never informed about. Gradually, these small instances of interference escalate into a full-scale campaign of disparagement. The child is told that the father does not love them, that the father is dangerous, or that the father has abandoned them. Imagine a man named Robert in the current year of 2026. Robert is a high school teacher in North Carolina, who has always been deeply involved in his 7-year-old daughter's life. After his spouse files for a no-fault divorce, Robert finds his access to his daughter slowly being choked off. First, his phone calls are ignored. Then, during his scheduled weekends, his daughter arrives acting withdrawn and suspicious. She begins repeating adult grievances that she could not possibly understand on her own. She asks Robert why he stole all of their money or why he hates her mother. When Robert tries to address these lies, the mother uses his frustration as evidence of an unstable temper in court. Robert is now trapped in a psychological hall of mirrors. If he fights back aggressively to see his child, he is labeled as high conflict or harassing. If he pulls back to avoid the stress on the child, he is accused of being an absent, disinterested father. This is the demographic trap that millions of American men face every year. The court system, which is theoretically designed to protect the best interests of the child, is often ill-equipped or unwilling to recognize the sophisticated psychological grooming required to alienate a father. Judges frequently take the path of least resistance. If a child says they do not want to go with the father, the judge simply stops the visitation rather than investigating the root cause of the child's sudden and unnatural change in behavior. The demographic impact of this erasure is staggering. Sociological historical trends show that children raised in fatherless homes are significantly more likely to experience poverty, drop out of school, engage in criminal activity, and suffer from long-term emotional trauma. Yet, the family court industry often facilitates this fatherlessness by rewarding the alienating parent with increased child support and absolute domestic control. For the man, the result is a profound identity crisis. He is told by society that he is essential to his child's development, but he is told by the legal system that he is an optional, secondary figure who can be replaced or removed at the whim of the state. This leads us to a critical, often hidden demographic shift in the late 20th century: the rise of the silver divorce and its impact on the aging American male. While much of the focus is on young families, a massive wave of divorces began occurring among couples who had been married for 20, 30, or 40 years. For men in this demographic, the divorce does not just represent a loss of a spouse. It represents a total liquidation of their life's work at the exact moment they are most vulnerable. Consider a man named Gregory, age 64, living in Florida in 2026. Gregory has worked for 40 years to build a retirement nest egg. He and his wife have an empty nest, and he is looking forward to the quiet years of retirement. However, the demographic data shows that the rate of divorce for people over age 50 has doubled since the 1990s. When Gregory's marriage ends, he is not just dividing assets. He is dividing a finite amount of time and capital that can never be replaced. In a silver divorce, the court applies the same community property or equitable distribution rules used for young couples, but the consequences for the man are far more permanent. Gregory is ordered to split his 401k and his home equity. Because he is at the peak of his earning years, he may be ordered to pay permanent alimony, a legacy of Old English law that assumes a woman has no capacity for self-support, despite the modern reality of a dual-income workforce. Gregory, who expected to be retired, is now forced to work well into his 70s just to cover his own basic living expenses and his court-ordered obligations. He loses the economies of scale that come with a shared household, and he often loses the social network that was maintained by his spouse. The data suggests that for men over 50, divorce leads to a significant decline in physical health and a massive increase in social isolation. Unlike younger men who may have the time to rebuild their wealth and start new families, the older demographic of divorced men often faces a steep, irreversible slide into poverty and loneliness. They become the invisible casualties of a legal system that treats a 40-year marriage like a short-term business merger. As we analyze these layers of destruction, from the financial extraction of Title 4D to the psychological erasure of parental alienation, and the late-life devastation of silver divorce, a disturbing pattern emerges. The American legal system has created an environment where the destruction of a marriage is often more profitable and socially incentivized than its preservation. But there is a final, even more complex layer to this demographic study. In the early 21st century, a new set of laws emerged that allowed for the total destruction of a man's reputation and career without a single piece of physical evidence. These laws were designed to protect victims, but in the hands of a skilled divorce attorney, they became the ultimate tactical nuke in the battle for assets and custody. How did the misuse of protection orders and the expansion of the administrative state turn every American home into a potential legal minefield for men? What happens when the mere accusation of a crime becomes more powerful than the proof of innocence? To understand how the modern American home became a legal minefield, we must examine the legislative evolution of the 1990s, specifically the passage of the Violence Against Women Act in 1994. While the stated intent of this federal legislation was to provide critical protections for genuine victims of domestic abuse, a goal that is universally recognized as vital, the implementation within the specific context of the adversarial family court system created a powerful and often abused legal tactical weapon. This era saw the rise of the ex parte restraining order, a legal mechanism that allows a judge to issue a restrictive mandate based on the testimony of only one party, without the accused ever being present or even aware that a hearing is taking place. In the demographics of divorce for men, the weaponization of protection orders represents a catastrophic shift in leverage. In a high-stakes custody or asset battle, an attorney may recognize that a man who remains in the family home is much harder to dislodge and more likely to secure shared custody. The solution within the modern legal machine is the strategic use of a temporary restraining order. Because the standard of proof for a temporary order is remarkably low, often requiring only an allegation of feeling threatened rather than proof of physical harm, these orders are granted with a frequency that would be unthinkable in any other area of criminal law. Imagine a man named Brian in the year 2026. Brian is a software engineer living in Seattle. He is in the middle of a contentious divorce, but he is still living in the family home to maintain a relationship with his two sons. One Tuesday afternoon, while Brian is at work, he receives a phone call from local law enforcement. He is informed that a temporary protection order has been issued against him. He is barred from entering his own home, barred from contacting his children, and barred from his own neighborhood. Brian has not been arrested, he has not been charged with a crime, and he has had no opportunity to defend himself in front of a judge. Yet, within minutes he is effectively homeless, his reputation in the community is shattered, and his legal standing in the upcoming custody battle is severely compromised. This is what legal scholars call the tactical nuke of family law. Once that order is in place, Brian is in a defensive crouch. He must spend thousands of dollars on legal fees just to get a hearing 3 weeks later to prove that the allegations were fabricated or exaggerated. Even if he wins and the order is dismissed, the damage is already done. The status quo has been established. The children are now living exclusively with the mother, and Brian has been branded with the scarlet letter of a domestic respondent. Historical trends show that once a father is removed from the home via a restraining order, his chances of securing 50-50 custody drop significantly, as the courts are hesitant to disrupt the new stability of the household, even if that stability was created through legal deception. The demographic impact of this extends far beyond the home. It moves directly into the professional life of the American male. We are living in a highly digitized society where background checks are instantaneous. A restraining order, even a temporary civil one, often appears in databases used by employers, landlords, and professional licensing boards. For a man like Brian, whose career depends on security clearances or corporate trust, a single unverified allegation can lead to professional suspension or termination. The family court system has effectively bypassed the constitutional right to due process, creating a scenario where a man can lose his children, his home, and his livelihood based on a single afternoon of testimony that he was not allowed to hear or challenge. But as we analyze the demographic wreckage of the late 20th century, we must also look at the massive expansion of the administrative state and its role in the surveillance of divorced fathers. The late 90s saw the creation of the National Directory of New Hires. This is a federal database that requires every employer in the United States to report the name, address, and social security number of every new employee within 20 days of their hire date. While this was framed as a tool to track down deadbeat parents, its demographic reality is a total state surveillance system targeted at men. Consider the case study of a man named Anthony, a construction worker moving between jobs in the year 2026. Anthony is not trying to hide. He is simply trying to navigate a volatile economy. However, because of the Title 4D incentives we discussed earlier, the state collection agencies are hyper-aggressive. The moment Anthony's information hits the National Directory of New Hires, an automated system triggers a wage garnishment. Often, these systems are not updated to reflect current custody arrangements or modified support orders. Anthony may find that 60% of his first paycheck is seized before he can even pay for the gas to get to the job site. This administrative overreach creates a demographic of men who are perpetually trapped in the informal economy or the gray market, because entering the formal workforce means immediate, and often inaccurate, financial decapitation by a state algorithm. This leads us to the contemporary demographic shift: the decline of marriage rates among the youngest generation of American men. Men in their 20s and 30s in 2026 have grown up as the children of the no-fault divorce era. They have watched their fathers, uncles, and older brothers be processed through the family court machine. They have seen the financial liquidation, the loss of custodial rights, and the psychological toll of being reduced to a paycheck. As a result, we are seeing a massive demographic retreat from the institution of marriage altogether. The data shows that for the first time in United States history, the majority of young men are choosing to remain single or cohabitate without legal contracts. They are performing a cold, rational cost-benefit analysis. They look at a legal system that offers zero protection for their assets, grants them secondary status as parents, and provides a massive financial incentive for the other party to dissolve the contract. In their eyes, the risk profile of a legal marriage is simply too high. This is not a rebellion against family. It is a strategic response to a hostile legal environment. But what happens to a society when an entire generation of men decides that the legal risks of fatherhood and marriage are no longer worth the potential rewards? What happens when the state-sponsored destruction of the male demographic reaches its logical conclusion, and the very foundation of the tax base and the social fabric begins to crumble? We are entering the most volatile era of American demographics, where the conflict is no longer just happening inside a courtroom, but in the very heart of the American economy. We are about to look at the emergence of the post-marriage era and the revolutionary new ways men are beginning to protect themselves and their wealth from a system that was designed to extract it. But is it too late to save the American family? Or has the demographic damage already become permanent? To understand whether the demographic damage is permanent, we must analyze the rise of the opt-out generation and the emergence of the strategic male demographic in the year 2026. This is a population of men who are not merely avoiding marriage out of fear, but are actively engaging in a sophisticated, data-driven assessment of the legal and economic risks associated with the modern state-recognized marriage contract. For the first time in American history, we are seeing a decoupling of committed relationships and legal marriage. Men are increasingly choosing to remain in long-term partnerships while explicitly refusing to sign the marriage license, effectively opting out of the jurisdiction of the family court system before the relationship even begins. This shift has created a fascinating and unprecedented demographic split. On one side, you have the legacy marriage demographic, typically consisting of older individuals or those in highly traditional religious communities who continue to follow the 20th century model. On the other side, you have the post-contractual demographic. These are men, often high earners in tech, finance, and specialized trades, who view the current legal landscape as a broken marketplace. They recognize that in 2026, the potential outcomes of a standard divorce include the loss of 50% of their net worth, a decades-long commitment to alimony, and the potential for custodial erasure. When these men calculate the probability of success, given that 69 to 80% of divorces are initiated by women, they conclude that the legal risk far outweighs the social or emotional utility of the government-issued certificate. Imagine a man named Marcus in the current year 2026. Marcus is a 32-year-old commercial pilot based in Charlotte. He has watched his father go through 2 divorces that wiped out his retirement savings and left him working late into his 60s. Marcus is in a committed relationship, but he has made a firm, non-negotiable decision never to legally marry. Instead, he and his partner operate under a private series of cohabitation agreements and separate property trusts. By keeping his assets in a self-settled spendthrift trust or a domestic asset protection trust, Marcus is utilizing legal tools that were once reserved only for the ultra-wealthy. This is a crucial demographic trend: the democratization of asset protection. Men in the middle and upper middle class are now using the same legal architecture used by hedge fund managers to insulate their earnings from the reach of state-mandated equitable distribution. This strategic retreat has profound implications for the American tax base. Traditionally, the stability of the middle class was built on the foundation of married, dual-income households that invested in real estate and stayed in the workforce for 40 years. As the male demographic shifts away from marriage, the housing market is beginning to feel the ripple effects. Single-person households consume real estate differently. They are less likely to purchase large suburban homes, which historically have been the primary engine for property tax revenue that funds local schools. The state, which once leveraged marriage to ensure social stability, is now finding that its aggressive divorce industry has poisoned the very well it depends on for long-term economic growth. We must also look at the demographic of the gig economy and its role in this new landscape. In 2026, millions of men have transitioned into decentralized, contract-based work. While this offers freedom, it also provides a level of financial opacity that makes the traditional wage garnishment systems of the 1990s look increasingly obsolete. The state collection agencies are finding it harder to automate the extraction of child support from men who do not have a single, stable employer. This has led to an even more aggressive response from the government, including the expansion of the Financial Institution Data Match System. This federal program allows the government to automatically scan every bank account in the country to find assets belonging to anyone with a child support lien. This level of state surveillance has pushed a significant portion of the male demographic into the world of digital assets and non-traditional banking. Men are increasingly holding their wealth in decentralized finance protocols or private equity structures that are not easily accessible to a local family court judge. This is a direct historical response to the decades of financial extraction we have discussed. The more the state has weaponized the bank account, the more the male demographic has sought ways to exist outside of the traditional banking system. This creates a dangerous friction between the citizen and the state, where the law of the family court is increasingly viewed not as a moral authority, but as a predatory entity to be avoided. However, the most significant demographic shift is happening in the legislative arena. As the percentage of unmarried men grows, so does their collective political influence. For decades, the divorce industry was lobby-proof because the casualties were isolated and silenced by social stigma. In 2026, that has changed. We are seeing the rise of organized legislative reform groups, composed of men from every socioeconomic background, who are successfully lobbying for the implementation of default 50-50 shared parenting laws. States like Kentucky and Florida have already moved toward a legal presumption that equal time with both parents is in the best interest of the child. This legislative shift is a direct challenge to the tender years doctrine and the psychological erasure of the father. For the modern man, 50-50 custody is not just about time. It is about the fundamental recognition of his humanity and his role as a parent rather than a paycheck. The data from these states shows a fascinating outcome. When the legal system removes the incentive for one parent to win and the other to lose, the conflict level of divorces actually begins to drop. If the state no longer rewards a parent for alienating the other, the tactical utility of parental alienation vanishes. But we are also seeing a counter-reaction. As men gain more custodial rights and better asset protection, the divorce industry is pivoting toward new areas of extraction. We are seeing the emergence of what experts call lifestyle maintenance claims, where alimony is being rebranded as a way to ensure that the lower-earning spouse can continue to live at the exact standard of income provided by the other, even after a short-term marriage. The goal remains the same: the long-term transfer of wealth from the male demographic to the state-managed single-parent economy. This brings us to a critical crossroads in American history. We have a demographic of men who are highly informed, legally protected, and increasingly disconnected from the traditional marital contract. We have a state infrastructure that is still optimized for the mass extraction of wealth through the divorce machine. The tension between these two forces is reaching a breaking point. What happens when the state can no longer fund itself through the dissolution of families because there are no more families left to dissolve? What happens to the social contract when an entire demographic of men decides that the only way to win the game is to refuse to play it? We are about to explore the final, most controversial stage of this deep dive: the future of American fatherhood in a post-marriage world and the radical new models of family that are beginning to emerge from the wreckage of the old system. Is there a way to restore balance, Or are we witnessing the final evolution of the American male into a completely autonomous legal entity? To address the question of whether the American male is evolving into a completely autonomous legal entity, we must examine the radical demographic divergence occurring in the year 2026, the rise of the parallel family, and the strategic adoption of private law. As the public family court system has become increasingly viewed by men as a high-risk, low-reward environment, a new demographic of fathers is emerging. These men are bypassing the state-managed marriage contract entirely and instead utilizing a complex web of private contracts, trusts, and LLCs to define their domestic lives. This is not a rejection of fatherhood or partnership. It is a sophisticated, historical adaptation to a legal system that has historically prioritized wealth extraction over familial stability. In this new era, we are seeing the emergence of the intentional co-parent. These are men who enter into relationships with a clear, documented understanding of custody and financial support from day one, often signed before a child is even conceived. By utilizing the principles of contract law rather than family law, these men are attempting to create a predictable legal environment that the state cannot easily disrupt through no-fault statutes or the broad discretionary power of a single-family court judge. This demographic shift represents a move from status to contract. Historically, being a husband or a father was a legal status with fixed state-mandated rules. In 2026, many men are treating fatherhood as a negotiated legal arrangement designed to protect their relationship with their children and their financial solvency. Imagine a man named Daniel in the year 2026. Daniel is a civil engineer in Texas who has carefully studied the historical trends of asset division and alimony we have discussed. When Daniel decides to start a family with his partner, he chooses not to obtain a state marriage license. Instead, they enter into a comprehensive cohabitation and co-parenting agreement. This private contract specifies that in the event of a separation, they will adhere to a strict 50-50 physical custody schedule. It outlines exactly how the household expenses will be shared and explicitly waives any claims to future income or separate property accumulated before the relationship. Because they are not legally married, the local family court lacks the jurisdiction to apply standard community property rules or impose permanent alimony. Daniel has effectively built a private fortress around his domestic life, using the same legal principles that corporations use to manage international joint ventures. However, the state is not sitting idly by as this demographic shifts. In response to the decline in marriage licenses and the associated revenue, some jurisdictions are attempting to expand the definition of common law marriage or domestic partnership to capture these autonomous men. In 2026, we are seeing a legislative push in several states to automatically impose marital-like obligations on couples who have lived together for a certain period, regardless of whether they signed a contract. This is a direct attempt by the state to maintain its extraction machinery by closing the loopholes that men like Daniel are utilizing. It creates a constant legal arms race between the individual seeking autonomy and the administrative state seeking to maintain its financial dragnet. This leads to a deeply troubling demographic phenomenon known as the fatherhood penalty in the gig and creator economy. As more men move away from traditional corporate roles and into decentralized work, the state has refined its ability to target their digital footprints. In 2026, state child support agencies are increasingly partnering with private data brokers to track the lifestyle and spending habits of men who claim low income but maintain a high-quality lifestyle. If a man is seen on social media traveling or purchasing luxury items while paying a modified support amount, the state can use that digital evidence to trigger an immediate audit and upward modification. The privacy that men once enjoyed in their personal lives has been virtually eliminated by the digital surveillance state, making every social media post a potential piece of evidence in a family court proceeding. The psychological impact of living under this constant surveillance is creating a new demographic of men who are hyper-focused on stealth wealth. These are men who intentionally minimize their visible assets and keep their financial lives entirely opaque. They avoid home ownership in their own names, instead using land trusts or corporate entities to hold property. They prioritize liquid, decentralized assets that can be moved or hidden from the reach of a court-ordered seizure. This behavior is a direct historical echo of the divorce tourism era of the 1930s, where men had to move their assets and their lives to escape predatory jurisdictions. The difference in 2026 is that the technology for both concealment and discovery has reached a level of sophistication that Josiah or William could never have imagined. But what about the children in this post-marriage world? The demographic data from 2026 shows a fascinating trend. Children raised in these private contract families often experience less disruption than those in traditional divorces. Because the rules were established at the beginning of the relationship, the high conflict, multi-year litigation that defines modern no-fault divorce is often avoided. When the legal stakes are lower and the financial outcome is predetermined, the incentive to engage in parental alienation or false accusations is significantly diminished. The autonomous male is discovering that by removing the state's profit motive from his family life, he can actually create a more stable environment for his children. However, this autonomy comes at a significant social cost. The decoupling of marriage and family is leading to a fragmentation of the traditional American community. Schools, churches, and civic organizations that were once built around the nuclear family are struggling to adapt to a demographic of men who are legally and financially independent, but socially disconnected. We are seeing the rise of male-only social clubs and mentorship networks designed to help young men navigate this new landscape. These organizations act as a parallel support system, providing the guidance and protection that the state and the traditional family unit no longer offer. As we look at the historical arc from the agrarian father with absolute custody to the industrial provider, the no-fault casualty, and finally the autonomous legal entity of 2026, we see a demographic that has been refined by fire. The American male has been subjected to a century of legislative experimentation, designed to extract his labor and his wealth. In response, he has become a legal strategist, a financial survivalist, and a protector of his own domestic sovereignty. But this evolution raises a terrifying question for the future of the United States. If the most productive, innovative, and protective demographic in the nation continues to retreat into private law and financial opacity, what happens to the public institutions that rely on their participation? We are approaching the final stage of this demographic deep dive. We have seen the destruction and the adaptation, but now we must look at the endgame. In our final part, we will examine the total collapse of the 20th century family court model and the birth of a new decentralized paradigm of fatherhood. We will reveal the one final demographic shift that is currently happening in the shadows, a movement that will either lead to the total rebirth of the American family or the final permanent separation of the sexes. What is the ultimate fate of the American father in a world where the state has no more power to control him? And what will he build from the ruins of the system that tried to break him? The final evolution of the American father in 2026 is defined by a total transition toward decentralization and the reclamation of paternal authority outside the traditional state-sanctioned framework. We have traced the historical timeline from the agrarian patriarch to the industrial provider, through the devastating demographic culling of the no-fault era, and into the modern age of digital surveillance and financial extraction. Now, we witness the birth of the decentralized fatherhood movement. This is a demographic of men who have realized that the 20th century family court model is not merely flawed, but functionally obsolete in a globalized digital economy. These men are moving toward a model of family that is governed by private sovereignty rather than public policy, effectively ending the era of the state-managed household. To understand this endgame, we must look at the emerging demographic of the globalized American man. In 2026, work is no longer tied to a specific geographic location for a significant portion of the male workforce. This has led to a phenomenon known as jurisdictional arbitrage. If the family laws in a specific U.S. state are predatory, high-earning men are simply moving their legal residency to jurisdictions, either domestic or international, that offer more equitable treatment of assets and more robust protection for parental rights. This is a massive demographic drain on traditionally high-tax, high-alimony states. When the most productive members of a society leave because the legal risk of staying is too high, the remaining infrastructure begins to crumble. We are seeing the beginning of a competitive market for fathers, where states and even countries are beginning to realize they must offer legal protections for men's assets and custodial rights just to keep their tax bases intact. Imagine a man named Ethan in 2026. Ethan is a senior cybersecurity analyst who has seen the demographic wreckage of his peers. He decides to relocate his entire legal and financial life to a state like South Dakota or Wyoming, which has modernized its trust laws to allow for the protection of generational wealth from the claims of civil litigants, including former spouses. Ethan lives in a jurisdiction where the law has been updated to reflect the reality that marriage is a choice, not a state-enforced life sentence of financial extraction. By moving his center of vital interest to a pro-sovereignty jurisdiction, Ethan has effectively opted out of the predatory family court systems of states like California or New York. He is part of a growing demographic of men who are voting with their feet, forcing a crisis in the family court industry as their primary revenue targets vanish. This jurisdictional shift is coinciding with the rise of the digital legacy movement. Men in 2026 are increasingly concerned not just with their physical assets, but with their digital sovereignty. They are using encrypted communication and decentralized file storage to ensure that their private conversations and family memories cannot be subpoenaed and weaponized against them in a custody battle. This is a direct response to the era of social media surveillance we discussed in previous parts. By maintaining a clean, private digital perimeter, the modern father prevents the state from constructing a false narrative of his character based on out-of-context data points. The demographic of the strategic father is one that prioritizes privacy as the ultimate form of asset protection. But what does this mean for the future of the American family unit? We are seeing the rise of the multi-generational male household. In response to the high cost of divorce and the fragmentation of the nuclear family, many men are moving back toward the agrarian model of cohabitation with their own fathers, brothers, and sons. This creates a demographic of male-centric kinship networks that provide the emotional and financial stability that was once provided by the traditional marriage. These households pool resources, share childcare responsibilities, and protect each other's assets from external legal threats. It is a return to a tribal form of social organization, born from the necessity of surviving a hostile legal environment. The data shows that men in these supportive male networks have lower rates of the depression and social isolation that defined the divorce demographic of the 1990s. We must also analyze the impact of artificial intelligence on the future of the divorce industry. In 2026, AI-driven legal tools are becoming available to the average man, allowing him to navigate the complexities of family law without the massive overhead of a traditional attorney. These tools can analyze thousands of local court cases to predict the potential outcomes of a specific judge's rulings, allowing men to settle cases based on data rather than emotion or fear. This is democratizing the legal process and stripping away the profit motive that has fueled the divorce industry for decades. When a man can see the statistical probability of his case for a fraction of the cost of a retainer, the incentive for attorneys to prolong conflict is significantly reduced. This is a demographic shift toward legal self-sufficiency. As the state-managed model of marriage continues to decline, we are seeing the emergence of the mentor-father. This is a demographic of older, divorced men who are dedicating their lives to teaching younger men the historical lessons we have covered in this masterclass. They are creating a new cultural narrative that prizes emotional intelligence, legal awareness, and financial sovereignty. They are teaching the next generation that being a father is not a role granted by a judge, but a biological and moral responsibility that must be defended with the same vigor as any other civil right. This grassroots educational movement is fundamentally changing how young men view the social contract. The ultimate fate of the American father in a world where the state can no longer control him is one of profound, independent authority. He is no longer a passive participant in a system designed to extract his value. Instead, he is a conscious architect of his own life. He understands that his worth is not defined by a child support formula or a community property spreadsheet. He is rebuilding the family from the ground up, based on mutual respect, private contract, and unbreakable blood ties. The demographic damage of the past century was severe, but it has produced a generation of men who are more resilient, more informed, and more strategically capable than ever before. The 20th century family court system was built on the assumption that men would always be the sedentary, industrial providers who would quietly accept the terms of their own destruction for the sake of social order. That assumption has been proven wrong. The demographic of the American male has evolved. He has become mobile, digital, and legally sovereign. The ruins of the old system are still visible, and the legal minefields still exist. But for the man who has mastered the history and the data, the path forward is clear. He is no longer the victim of the demographic trend. He is the one who sets it. But even as this new era of autonomy begins, a new set of challenges is appearing on the horizon. As men become more independent and harder to extract from, how will the state respond to maintain its tax revenue? We are seeing signs of a new form of digital taxation, and the potential for a social credit system that could be used to penalize men who exist outside the traditional marital framework. The battle for the American family is not over. It is simply moving to a new, more complex digital front. In our next deep dive, we will explore the rise of the digital social credit state and what it means for the future of male sovereignty in the United States. The rules are changing again, and the only way to survive is to stay ahead of the data. Are you ready for what comes after the end of the family court era?